Hi, my name is Catherine Dove. I am your instructor for the 5.5-week course in contracts for paralegals. I have been teaching here at Rasmussen for 10 years. I've been teaching altogether for 22 years, since 1998. I am an attorney. I have practiced business law in California. And I actually won an American Jurisprudence Award in contracts. So contracts is one of my favorite subjects to teach. And I'm really looking forward to helping you navigate this 5.5-week course in contracts. Let's get started. We are going to be covering an introduction to contracts for Module 1, and I will be presenting a slide presentation for you, and we will also be discussing your written assignment for Module 1. Terrific. So this is PLA 10140 contracts. We are going to start out by taking a look at the course in Blackboard. I'm going to share my desktop with you. And we're going to take a look at the Blue Book guidelines and also some of the tools that you'll be needing to use this term. Sharing my web browser. Going into Blackboard. Blackboard is our learning management system. It is how you will access the course. This is section 1 of PL 140, PLA 1423. Clicking on the course. So here's our online course. We are starting out with the Getting Started. So everyone should take a few moments, click on Getting Started. This is going to give you a course schedule and let you know what you need to read for every week of the course. So starting out with Module 1, you will want to spend a few hours reading in your textbook, Contract Law for Paralegals, Traditional and E-Contracts, Chapters 1 and 2. You will also want to click on the Student Lounge. And take a few moments to introduce yourself to the class. And I have my introduction there. and feel free to reply and say hi to me and get to know your classmates. We are starting out with Module 1, an Introduction to Contract Law. There's a video you should watch explaining what is a contract. I think videos are a terrific way to learn, and they will be embedded throughout the course. In addition, I have embedded a link to flashcards that you can use. They're my favorite study tool for learning all of the terms that you'll need to know in contracts. Starting out, if you want to know what a valid contract is, you would simply click on the bottom. A valid contract requires offer, acceptance, and consideration. Clicking further, you'll see your Module 1 written assignment. In this assignment, you will consider a scenario where a paralegal is interviewing a client to discuss a breach of contract action. You'll be looking over the facts of the case, coming up with some ideas on how to proceed. For every assignment, there's a grading rubric. If you're one of those people who wants to make an A, take a look at the grading rubric. It will tell you where your points are coming from. And your assignment will be graded using this rubric. I will simply be reading your assignment and then checking off the criteria on the rubric to make sure that you've met the criteria. Other helpful resources can be found by clicking on Books and Tools. In particular, the course syllabus, has my name, my office hours, phone number, should you want to contact me, my email. We will have a weekly live session, which is a chance to get to know you, your classmates, me, and it's also a chance to get your questions answered. That information is here as well as the competencies for the course, determine the validity of contracts, edit contracts involving merchants based on the Uniform Commercial Code, analyze issues related to common law contracts, edit contract drafts, analyze contract defenses, analyze drafting and signature requirements for contracts. Take a look at that. The grading scale, incomplete grade policy, and our academic integrity, which basically requires that you submit your own original work. Do not use any homework websites like Course Hero, because see, I've been teaching since 1998. So therefore, I've already seen all the other papers out there. I've seen all the plagiarized essays. And if you submit something that's plagiarized, I'm going to know immediately because I've seen it before. And an act of academic misconduct, such as plagiarism, can result in you getting a 0 on the assignment. Repeated violations of the academic integrity policy can result in your expulsion from the university. So be sure to read the course syllabus. If you scroll to the bottom of the page, under course materials, you will find the e-text, the electronic textbook, I clicked on e-text, and it's launching the e-text link. I just opted out of cookies. We require cookies. Contract Law for Paralegals is our textbook. And Module 1 requires you to read chapters 1 and 2. Be sure to take the time to read that information because it will be very important when you start getting to your quizzes. It's an excellent textbook. I've been reading it all week. It's very good. So let's go back. I'm going to stop sharing my screen with you. And we will get started. So what are we going to be talking about this term? Well, we're going to be talking about contracts. Contracts are in our daily lives everywhere we go. Employment contracts, labor contracts, contracts for sale, oral contracts, written contracts, implied contracts, bilateral contracts, all kind of contracts. So, well, what is a contract? A contract is a set of promises for which breach of law is the available remedy. Who are the parties to a contract? The offeror is the person who makes an offer to enter into the contract. The offeree is the person to whom the offer is made. There are 3 elements of a valid contract. This you must know: offer, acceptance, and consideration. An offer is an expression of an intent to be contractually bound to specific and definite terms. Acceptance is the act or the promise of a party indicating a willingness to be contractually bound by the terms of the offer. And there is a mirror image rule that says that the terms of the acceptance must mirror the terms of the offer. If the acceptance changes the terms, then that is a counter offer. Consideration is the 3rd element of a contract, and it's anything of legal value that is bargained for. Whether it's I offer to sell my textbook to you for $100, we're bargaining for the $100 in the textbook. I offer to sell you my car for $5,000. The car and the money are the consideration that support the promises. This is all discussed in chapter 1 of your reading. We'll be looking at various classifications for contracts. Contracts may be written or oral. Contracts do not have to be in writing. If I promise to sell you my textbook for $100 and you say, I accept, I will bring $100 tomorrow, that is an oral contract. It's completely enforceable. It would be nicer if we put all those terms down in writing or even in an email, because a written contract is easier to enforce in a court of law. You can certainly prove it a lot easier, but oral contracts are enforceable. Let's take a look at an example of an oral contract. Anne talks to her next door neighbor's son, Bob, and asks Bob if he will mow her lawn for $20. Bob doesn't say anything to Anne, but he does go grab his lawnmower. He puts gas in it. He pushes it over to Anne's house, and he starts mowing her lawn. Has a contract been formed? Yes. It's an oral unilateral contract. It's unilateral because it involves one promise, a promise to pay $20, and Bob accepted that contract not by making a promise, but by performing, by mowing the lawn. So by accepting her offer, a contract's been formed. It's oral because it's not been written. It's unilateral because it's only one promise being exchanged for his performance. It's a valid offer with specific and definite terms. He accepted the offer by mowing her lawn. If he had said, I promise to mow your lawn tomorrow, that'd be a bilateral contract. because it would be exchanging two promises. So let's talk about the offer, the first element of a valid contract. A complete legal offer contains a promise of future performance. I promise to sell you my textbook if you promise to bring me $100 tomorrow. That's an offer. It has to have specific and definite terms, a description of what each side gets. I get $100, you get my textbook. 3, a way to determine when each side has to perform. Performance can't be indefinite. It can't be like, you next year I'll sell you my textbook if you bring me $100. No. It has to say what the time frame is. It has to be reasonable. And it would certainly help if the terms were in writing. Make it much easier in the event of a breach. Well, what is an enforceable contract? If the offer is accepted, it immediately becomes a contract that's enforceable in a court of law. An example is a clothes washer purchased on a rent with an option to buy or a rent-to-own plan. When I first got out of college, I remember not having very much money, moving to a town to accept a job, and I had to go to a rent-to-own place to buy furniture. And I entered into a contract. I signed the terms of an installment agreement. You paid a certain amount every week, and as long as I paid that amount every week, I was renting to own this beautiful furniture. So the seller has to deliver the washer described in the contract at the time of the contract, whatever time we agree upon. There cannot be any uncertainty about which item is being sold. The time of delivery should be specified as well. The offer dollar amount needs to be specified. The times of payment need to be covered in the offer. An enforceable offer will include the price, the consideration, and the specific terms. Imagine that Bill wants to be hired by Ron in June to paint their house. Bill's a contractor. All of the terms are oral except for a brief unsigned bid that's not a complete sentence. Paint Ron and June siding on their house, $1,500 for labor, homeowners to pay for supplies to be completed this summer. The rest of the terms are oral, including information such that it has to be done in a workmanlike manner. Bill is to scrape and paint with a primer. He has to use a top coat. He must use the paint that Ron and June choose. Bill needs to bring his own ladders. If the homeowners agree to that, that becomes an enforceable contract. They accept Bill's offer, even though not every single term is spelled out in writing. That's enough for a contract. Let's take a look at your Module 1 written assignment. So the Module 1 written assignment requires you to consider a scenario where a paralegal is interviewing a client about an oral contract. You want to take a look at the scenario. And in your own words, write why an attorney would recommend that an oral contract be put in writing. Even though an oral one is valid and there are witnesses to the terms, why might you want that to be in writing? Use the lesson notes. Comment personally on the transcript of the client interview. How do you feel about the way the paralegal interviewed the client? What would you change? If you were the interviewer, would you use a printed intake form when a client comes into your office? Would you mark the intake form in handwriting? What other methods might you use to take notes when the paralegal is interviewing a client? Also, recommend 3 open-ended questions that the paralegal should ask the client in a follow-up interview about this oral contract. And 2 questions where the paralegal might ask the client for some documents. Based on what you know so far, was the oral agreement based on a complete offer or an incomplete offer? Argue both sides based on the lesson notes in Module 1. Specify areas of uncertainty. In completing the Module 1 assignment, you have the option of using the application table to compare incomplete and complete offers and identify the characteristics and terms of the complete offer. There's a table that will help you apply the facts of the assignment scenario to the legal issues and the cited authority from the readings. So when you are writing about the law and doing an assignment, you always want to cite to legal authorities. And in this case, that would be cases, any relevant cases about definite offers and enforcing oral contracts. So your assignment should be 3 to 5 pages in length, which is double spaced. So, that's not a lot. 3 pages double spaced is like 1.5 pages single spaced. So 3 to 5 pages with at least 3 references formatted according to Blue Book standards. See the rubric for details on how your assignment will be graded. So let me go back into the classroom. I'm going to go into Blackboard. I'm going to take a look at the class again. We're going to look at the details of this assignment. And we're going to take a look at some of the requirements for the assignment, and in particular, the Blue Book citations. Whenever you are writing about the law, you need to make sure that you follow the Blue Book cites. So we're going to take a look at the Blue Book. Fortunately, there are live links to the resources in Module 1 under your assignment. So there's the assignment. Again, what happened is Leo, the owner of Riverway Construction, offers to re-roof the client's one-story house for a lower price than anyone else bid. They were not exactly happy with the work done. They didn't pay the labor materials that he sent. And it's a question about how to enforce this oral contract. So you want to read the scenario, answer the questions. Let's take a look at the requirements. Your paper should be 3 to 5 pages in length with 3 references formatted according to Blue Book standards. So as paralegal students, you want to become very familiar with Blue Book. The Indigo book, the Manual of Legal Citation, is the preferred Blue Book form. Here's the electronic version of it. You'll be citing the cases. An example of a case citation. Case name. The volume. 88 Fed Sup. Page 116. Page 127. 116 is where the case starts. If I was to pick up Fed Sup, Federal Supplement, it's a book of federal cases. If I was to pick up volume 88 and turn to page 116, I would find this case, Leonard versus Pepsi. And this comma to 127 means that on that page, I find the point of law that is relevant that I'm going to use in my essay. And in this parenthetical, plaintiff's understanding of the commercial as an offer must be rejected because the court finds that no objective person could have concluded that the commercial was actually an offer to consumers of a jet. So if I wanted to use that information about what legally constitutes an offer to contract, I would cite to this case. That citation there is what you would need to include in your essay. That's the Blue Book standard. Okay. Now, how would you find resources? Well, you might do research using Lexis or Fastcase. Again, I'm clicking on the legal resources, looking at Lexis Advance. You can always make an appointment with a librarian to learn how to use Lexis Advance to do research. If you ever need tutoring, you can click for Tutor Match. So help is just one click away. If you have any questions, feel free to ask. Okay, great. And we looked at the rubric already. So this is your introduction to contracts for paralegals. Every week, we will be having a live session in real time where you can get to know your classmates. You can ask me questions. We can communicate about some of the contract principles we'll be studying this term. Every Wednesday at 6 p.m. Central Standard Time. I'm on the West Coast out in Nevada, so it'll be 4 for me. So you should adjust based on your time zone. On the East Coast, that'll be 7. You want to use that following link, cut and paste that into your web browser. And I look forward to seeing all of you in the live classroom on Wednesday. We'll be here, we'll be chatting, we'll be learning about contracts. This is going to be a terrific 5.5-week course. It's going to go by fast, so be sure to stay on top of all of the assignments and be sure to attend the live sessions. If you have any questions or concerns, feel free to email me, give me a call. My e-door is always open to you. Let's have a great term. Thank you.